I am very interested in technology and having our students understand more about tech and how it can work in practice. Been at St. Thomas now, let's see, it'll be 4 years in July. Hard to believe it's been that long. I've almost gotten used to winter, sort of, but not quite. So thanks for asking me to attend, Mike.
And if I'm not mistaken, you are the co-founder of the tech track at the tech show. Is that? I'm sorry, the tech track, the academic track at the tech.
Yes, you could say I'm the godfather of the tech. So back in it was 2012 or 13. Adriana Linares gave me an opportunity and some of my colleagues to have a sort of in the middle, not an official part of the show, create an academic track that brought. We were noticing that there were many law schools that were sending people, but there was no sort of unified effort to figure out how to have the academics talk to the practitioners. And so 2 years later, the academic track was officially adopted by the show. And I forget which year it was, but Dan Katz was the keynote speaker. So we were all academic all the time. But last year, Heidi Alexander and Catherine Sanders Reach, who were co-chairs, rebranded the academic track to the Next 20. And so that's supposed to be more focused on not so much, what we do in law school, but how law school can do a better job of getting students ready for technology. It didn't quite, some of the things that were in Next 20 this time around weren't quite what we had envisioned, but we're still kind of figuring out how to make that work.
Thanks, Michael. And Sam Glover, I think everyone probably knows you from Lawyerist primarily. Tell us a little bit about yourself.
Hey, everybody. If you know me, it's probably because I co-founded Lawyerist a while back, and I was able to leave Lawyerist was it June 1st, I think, of last year was my exit, because I was ready to do some new things. And so what I've been working on since then is 2 projects. I'm not really sure where they're going. The first is Client Power Tools, which is a WordPress plugin to add a client portal to your website. Most people with websites are on WordPress, and so I felt like that was a good place to go. It's free and open source. If it ever goes crazy, I have an idea of how I might sell some premium features for it, but right now it's just straight up free and open source, and I don't see that there will never be a paid core version of it. It's pretty cool. I'd be happy to show it to you at some point, but there's a demo on the site too where you can check it out. And then the second thing I've been working on is Reinventing Justice. There you go. Which is sort of I have been following legal innovation for my entire career, and I have been frustrated by how hard it is to get your head around what is actually happening in that space. What are the kinds of things people are working on, and then most acutely, like, who are the people working on that? So people would always come to me and say, who do I need to know about in AI and legal? And there are definitely a handful of other people who, like me, kind of are, because of the podcast in particular, but there are a handful of other people who are sort of on top of that and would be able to rattle off some names. But there isn't a great place to go find out. If I'm interested in who's working on regulatory reform and law, who should I be talking? Like, who's doing that work? And it's frustrated me that there isn't a great place to find that. So I'm trying to create it. And so on the front page of Reinventing Justice is a list of innovations, the main things that I think are moving in law that are interesting to pay attention to, a list of innovators who are doing those things. And then I don't have a better name for groups for like organizations, academic projects, programs, companies and stuff. I'm not trying to make it a directory of startups. It's mostly about people. I think it may be trending towards being a book one day. We'll see. But it's very incomplete. It's definitely a work in progress. I would think of it more like a notebook. But my list of innovators is kind of the core of it, and where my hope is maybe eventually, and you see it shows what are they working on, what groups are they associated with, and it's bold if they're sort of a key innovator in that area, and you can sort it and filter it a bit. And my hope is that eventually that becomes, maybe there's even a way to build a community around that, where, we were talking about Discord and Slack at the beginning. I've thought about, should I be spinning up a Discord server for this, so that if you want to just, if you are somebody working on, AI or legal education, you can very easily just jump into a chat with the other people who are working on it. I don't know. So there is no business model for this. I hope that it is eventually the kind of thing that somebody would want to sponsor, but it's never going to be a big thing. It was mostly just because I felt like I wanted this to exist, so I wanted the information that's in it. And I think, like, actually one of the more practical applications of this, I think, is it becomes a list of the people that you would want to speak at your conference if you're doing a conference around legal innovation. And I think it's already a useful tool for that, especially because I'm trying to highlight BIPOC folks and women. There's a filter on there where you can just highlight BIPOC and women. And I think that makes it a pretty useful list for anyone who's not sure where to go to not just have white dudes on their panels. Yeah, so those are the two things I'm working on. I've left Lawyerist, but I'm still an owner. We're not enemies or anything, but I've left in a way that I have some time to make the next thing work, which is awesome. And so I hope that one of these two things turns into my big next thing, but we'll see.
Must be pretty satisfying. In fact, I imagine to build a business like Lawyerist to the point where you can leave it. You're not the
yeah. Yeah, I mean, I'm not gonna lie, it was pretty amazing when I don't know if people are familiar with, like, the concept of visionaries and integrators, and there's a what is the name of the business system? Traction is the business, the book and the system for organizing business. But the idea is that you need one person who has, is the visionary leader, and one person is the make shit happen person. And Lawyerist had kind of gotten to the point where Aaron and I were both visionaries, and it kind of is hard to have a company that way, which didn't mean that we were fighting or anything. It's just that it didn't need both of us. And I had sort of yielded the vision to Aaron years ago when we set it on its current trajectory. And so it seemed logical for me to be the one to step back and let him and Stephanie run with it. And so so far so good. It does feel great. It's pretty amazing that was always my goal, is to make myself irrelevant to my own company so I could walk away from it. And then when I was finally able to do that, felt like a big win. So yeah.
Well, great. Let's chat about the tech show a little bit here. Maybe we can use your recent article as our crib sheet.
Yeah, sure.
These are some of the themes I think that we exchanged in email earlier on, and some of the items that I was thinking about when I attended as well. The document piece here in particular. I thought was the Startup Alley competition had a number of automation.
9 out of, by my count, 9 of the 15 were concerned with documents in some way, reading them, making them, analyzing them, whatever. So
now what was interesting about the startup competition is none of them won. I thought the startup competition was interesting. I think I do want to talk about the document automation piece, because there was a ton of references to that. But the startup competition, one of the things that's interesting, I thought, Freelance for Law was the winner this year, which is not the other popular one, which I don't think made the top 3, was the virtual office space where you.
I thought Painworth was the most interesting one, but
really,
obviously. So.
Interesting presentation from Painworth as well. But we saw a lot that not I wouldn't say tech forward type of companies there. the freelancing, those tools have been around for a little while. Fastcase has got a tool for that. Law Clerk has been around for a little while. I just thought it was interesting. But what was interesting about it is everyone voted for Freelance for Law, which sort of made me feel like that there's a need there for outsourcing solutions. That maybe that's what
it's one of those needs that like it already exists.
Yeah.
If there's a need, like all you have to do is go sign up with Law Clerk.
That's right.
There's a really good solution already. It's always kind of funny to me when people are like, "Oh, I voted for that because I wish it existed." It does.
It exists. I know. Yeah. Well, and that's what's interesting about the voting. I mean, this competition doesn't have I was thinking like Dorothy AI, or it was that what it was called, Dorothy AI. So the patent searching tool. I thought it was a great presentation. Explain how they would improve your bottom line. Very convincing argument if it works. I had lots of questions about how does the AI work against if you're a mechanical engineer or a chemical engineer or because of certain patents. Anybody who's done patent search knows that's can be very difficult if you don't know the technology that you're searching. And so I had questions about it, and, very limited application, 500 participants aren't going to vote for Dorothy AI because, one or two of them are actually patent attorneys,
it's a very niche
right?
product, yeah.
So, but maybe there's an innovation there that is super interesting. One of the questions I had about the tech show, whether, this sort of popular voting for the tech show, or should it be more of a Shark Tank type of Q&A setup?
One of the things that I think is worth considering about the startup pitch competition is many of these startups are sort of birthed from the crucible of startups in around Silicon Valley or the hubs around the country, or they're sort of they're at least in that mind space, if not in that physical space. And just because of the nature of the legal market, almost all of them are conceived with big firms as their customers, right? Very few small firms need the kind of document management that a lot of these startups were offering, because we're not doing mergers and acquisitions as small firms. If you're at a big firm, you absolutely are, and those might get more interesting to you, but you're probably not interested in startups at that point. Because you need to be, just as you said, like it's going to take you some time to prove that it's going to work and enhance the value that you offer to your clients. So startups have kind of a long road with big firms, but that's what's kind of interesting to me about the startup pitch competition is like the nature of startups is very few are designed to appeal to solo and small firms. Most of them are designed to appeal to medium and large firms, and Tech Show is mostly designed to appeal to medium to solo firms, and so there's a little bit of a weird the
Venn diagram is
don't necessarily intersect in a big way.
So Mike, did you see the chat?
Yeah.
I think it's Bob Ambrosie's site's probably the best place to direct.
And they, as part of their contribution, put in their application asked them for a video, so they're little videos for that. Let me find that separately here.
Yeah, actually, the one that I was interested in didn't even make the cut, or the one.
Which was your favorite, Michael?
This was well, it was in the document space as well, but I thought they did some innovative things with the search capability they had, but they didn't make the cut. So not that I lost interest, but it's like, okay.
Yeah, I did like some of the clause finder. I thought was sort of an interesting option. Term Scout, I think, or clause-based Term Scout. Some of those sort of met my current needs, and I thought, oh yeah, that's a problem that I have. Using my existing documents as my knowledge base for building other documents. I thought those are pretty good. To Sam's point, there have been in the Startup Alley competition, folks who are targeting smaller law firms. So that was what was the name of the e-discovery? This was maybe last year, the e-discovery resource that was
Woodpecker.
Woodpecker is a document automation, but there was a e-discovery tool, Discovery Genie, I think they were called. Which
let's do a little exercise here and see if they still exist. Because that's the other thing about the startup competition is.
Well, and they were charging per document, so it was a.
Oh, they're still out there. $1.13 per document. What a weird price.
Yep.
And honestly, just charging per document is not a crazy pricing model. Like Kira Systems, which does AI assisted document review, I believe charges per document as well. In part because, like, when you're thinking about doing a merger or something, or big business move, one way to price that is, and one way to think about pricing is, how much time are we going to have to spend per document of the 100,000 or 100 million contracts we're going to have to review. So charging per document is not a crazy way to do it.
And it's predictable.
Yeah.
For
when you're doing your RFP to your client, you're likely to phrase it in terms of, we think it's going to take an average of 20 minutes per document or 45 minutes per document, and so that's how we're arriving at this estimate.
we got the Bob Ambrosi link here. And their argument, Discovery Genie's argument was, that most cases don't involve, the kind of thing where you need maybe the big AI tool for your review.
Yep. And $1.13 per document is actually ridiculously cheap.
Is it?
Well, you think about it. So, like, if you're a big firm, you're probably, maybe today you're averaging it out to more like 20 minutes a document, but 20 minutes of lawyer time is not $1.13, right? 20 minutes of lawyer time is what, 75, 85, $100. So if you have an AI that lets you cut that time, it's a huge value to your client to pass through.
Some of the links.
I think I've been reading Kira's AI for Lawyers book, and they're assuming that that your AI software will charge you about $10 per contract. So $1.13 is dirt cheap.
Is cheap.
Yeah.
So the link I just dropped in was I went back in time a little bit, not to give just the winners, but the finalists, which I think will give you the links to, if there was a video available, so you get to see what they were up to. Because I think that's the more, rather, the winners are less interesting than
the winners are not the thing.
Yeah.
Do they get a prize? I don't even know what they.
I forgot. I was going to ask because it used to be.
If they get a prize.
Money. Yeah, we were chatting online about the long-term viability. So like Tally, for example, which is kind of a cool tool that voice activated your smart speaker, keeping track. Yeah, it's like.
I don't think smart speakers belong anywhere near attorney-client conversations, but okay.
Yeah, probably not. But most of the practice management platforms now are tracking your keystrokes, aren't they? To some extent, to say.
I don't think so.
Well, like Smokeball, for example, don't they have sort of a friendly bot, or I forgot sort of what the terminology is there, to track your time, to say, hey, you've been an email for certain, so I don't think they're tracking. Yeah, keystrokes is not the right term. Your content, but
they're finding whether or not you are active in a particular window or document or something like that.
Right,
yes.
right.
Yeah, there are a number of those now. Yeah,
which I think is. Helpful if you're still billing by the hour. There's I didn't hear many conversations about the billable hour at the tech
I heard
show.
what I thought was one of the larger themes that I took away from it, that I'm not even sure that I did a good job of discussing in my post, but I felt like we are getting close to sort of a critical mass of lawyers who have gotten away from the billable hour and away from traditional practice, like especially among the presenters. There were a lot of the presenters who, I go to look at their websites, I listen to them talk, and they are doing things very different from a traditional law firm. And in a way that, to me, if I put myself in the shoes of the consumer, I don't know why I would ever go to a firm with a more traditional website and try to contact them. Like they're offering flat fees or subscriptions, or in ways that make sense to me as a consumer of everything else in the world today. they're letting me click a button to sign up on their website. I can just enter my credit card information, and I'm at least provisionally a client presumably until they do their conflict review. And to me as a consumer, I'm like, this is fantastic. They're speaking directly to my concerns and frustrations with working with a company like a lawyer, and it felt like we might be either approaching or just getting over the tipping point that so many of us have been talking about for so many years, of where law practice is starting to look a little bit different.
I think that seemed
So-
exactly right to me. That they're right at a tipping point here. There's sort of and I may be underthinking this a little bit, but you have the sort of the shop tours of the law firms, which are fun. Just here's my tech stack. Here's what's going on with I use with some of the popular ones. Somebody was using Monday.com, not using any of the practice management. So it was fun to kind of see what they were building and how they were integrating those features, and what their zaps look like and things like that. And then and in those you saw use of tools like Afterpattern and Woodpecker and some of these automated tools. And then as a separate in the future proofing, sort of you have the forward thinking set of programming at the tech show that says, well, have you considered, a subscription service? Have you considered productizing your practice in any way? So it's on both sides of those. It's both in the setup and in the sort of the future of the profession type of conversations, which I thought was interesting.
It makes me feel optimistic, because I feel like, I've been beating the drum for this for 13 years plus, and it feels good. I mean, to be fair, I've worked with a lot of those people, or had what I think are pivotal conversations with a lot of those people over the years. So there's definitely a little confirmation bias here on my part. And I should probably acknowledge that. But like a lot of the people who are up there on stage talking about their subscription programs and things like that are alumni of lawyerists programs, and so that's where they learned it. And so like, I'm proud of that, but I'm also there's a little confirmation bias there. So Timothy Bayland just asked, are subscription fees ethical? Yes, it's yes.
It was interesting. One of the conversations was stop thinking. It wasn't stop
asking that question. Sorry, Timothy.
Tim, we love you. But
the ethics boogeyman is always rearing its head.
Always there. Yeah, there are a couple of conversations about the rules are not super complicated around this issue.
They're not, and they're not a barrier to any of it. So
yeah. I mean, but there are considerations, with the retainer fees and things like that. But that was one of the, usually it's what, of course you can have a paperless law office. This year was,
oh my God, I went paperless in 2005.
In 2005, right?
And I went paperless because the Minnesota Lawyers Mutual was already paperless and was preaching to their members that they should be paperless. Right. And so if a slow-moving insurance company was already paperless in 2005, 16 years later, yes.
I would be interested to know how, I know Tim is I think he's using my case. Sorry to out you, Tim.
That's right. Yeah, you stuck your head out. We're going to pick on you.
So sort of thinking about adopting this as subscription services for with some of the practice management tools. I don't know. The Clio's whole thing is the hourly billing piece. With something like your client portal, you could deliver on some of these things maybe without. And I'm not sure that the practice management platforms are sort of set up for this productized future.
Some of them are. This is sort of like an extension of what I was talking about. Most of the startup pitches come from companies that are built around clients that are at medium and large firms. I've had this conversation with Clio several times, but Clio is a great example of this, because they are trying to define the cutting edge for what practice management software is. but you obviously can't design a product for customers that don't exist yet. And so like there isn't a critical mass of firms billing subscriptions yet. And so Clio doesn't really support it. They might actually support it now finally, but it's always a balance between building software for what people are doing now versus building software for what you think people will be doing in 5 years but aren't currently. And so Clio is trying to push that edge forward and skate to where the puck is going, to use a tired metaphor. But it's hard, right? You have to build a product for the customers you have today, not the customers you think you'll have in 5 years. But you'll never have those customers in 5 years if you aren't at least anticipating where they're trying to head.
Right.
So there's always a little push pull.
And I think with the other side, and the idea of the latent legal market is often a topic in these conversations. This idea that there's a number of folks who are willing to pay for services who may not qualify for legal aid, but can come up with $600.
In doing my research for Reinventing Justice, it's pulled my perspective up higher than it was. I was very much in the solo and small firm world. And I think the latent legal market might be bullshit.
Really?
I think it might be a bullshit concept. And part of it is because, so like Clio points this out in their legal trends report, and other people have pointed it out again and again. I think it's totally true that like there is a weird mismatch where lawyers' fees are still up here. And if you believe all of the reports, legal demand is, yes, they're both high, right? Fees are high and demand is high. One of those should drop. Like that's how the seesaw that we all learned about works for supply and demand. But it's not moving. And it's not moving because it's sort of a protected industry, but partly it's not moving because like I've been harping on this for a while. Go back and look at Rebecca Sandifer's reports for the ABA. Most people don't want to hire a lawyer. And in fact, most people don't hire lawyers to solve their legal problems, and it has nothing to do with affordability. People don't want to hire lawyers to solve their legal problems. And in fact, and this is kind of what I think is the headline from Rebecca Sandifer's work, is the conclusion is lawyers are the least popular way to solve legal problems. And I don't think there's a latent legal market for lawyers. I think there's a latent market for other ways to solve legal problems. And I think that's something that the profession is just maybe not even beginning to wake up to, but needs to wake up to, is the fact that there might not be a latent legal market because lawyers are already, like we are and we have been for years, the least popular way to resolve legal conflicts and solve legal problems.
So something like Utah's regulatory sandbox, maybe a better.
Yep, I think those are. But I also just think the law, the legal profession may be irrelevant to this. It may not be our maybe just don't worry about it because we're not going to fix it because people don't want us to be involved in fixing it. That message seems loud and clear from the actual data and the actual research.
She one of your.
She's an ABA fellow, and she's been doing. She is one of the innovators there, and there's some links to some of her work under her name. You can sort by alphabetical, and you'll have an easier time finding it. Rebecca Sandifer.
Yeah, you just passed it, Mike.
Yep, yeah. Sorry, there we go.
There she is. So she's a fellow with the ABA Center for Center for Innovation, but she's also been doing or American Bar Foundation, and so she does a lot of work trying to put real numbers around access to justice and what that actually means. And her access to justice in the contemporary USA is, people have cited it all over. But I think when you view through the window of just like, when you're in the world that we are all in, and that I sort of just escaped, as it were, you're viewing things from how can we fix this problem? Right? Like, how can lawyers fix this problem with the legal market? And connecting those two seems obvious, but I think when you read Accessing Justice in the Contemporary USA, you can't avoid concluding that we might not have a role in fixing 80% of the problem. Like, the access to justice gap may be the part of this problem that lawyers can't solve, which is sobering and weird to get your head around, but I think is right.
Did you, Sam, see the presentation by the Arizona Supreme Court Justice? What did you think of that?
Oh man, the I'm great. I think what they're doing is great. And to summarize for those who weren't there, I think there's two really important things that Arizona has done. They've done away with the unauthorized practice of law prohibitions, which is long overdue in my opinion. They aren't real anyway. As a librarian, I'm sure you've been answering legal questions from people who
Never.
maybe you're not a public facing librarian. Everyone I know who works at like the Hennepin County Law Library gets people walking in and asking legal questions all the time, and I mean they answer them because they do that. Public interest is the same thing. People are always asking questions and answering them. The self-help desk has wrestled with this. There are lots of people delivering legal advice who aren't lawyers, and everyone is fine with it. Anyway, so that's on the one side. I'm definitely an enemy of unauthorized practice of law rules. But the other thing they did was they did away with Rule 5.4, and 5.4 in the model rules is the rule that prohibits non-lawyers from owning an interest in a law firm or from sharing legal fees. And they found that, I wrote this down because I liked it so much. They found that Rule 5.4 protects lawyers but not the public, which especially now that in lots of other countries have done away with that same prescription, it seems obvious. But there's no reason why non-lawyers shouldn't own and couldn't own an interest. And the way this works is essentially, in order for a non-lawyer to own an interest in a law firm, they have to agree to be bound by the ethics rules. So, which there has been so much discussion of how in the world would you regulate a firm that includes non-lawyers in its ownership? And they're just like, if you want to own an interest, you just have to promise to be bound by the ethics rules. Done. So there you go. So those are the two main things they did in Arizona. They're also they're licensing legal technologists, or what did they call them? They came up with a slightly shorter acronym for LLTs. Yeah, they came up with this shorter acronym, but I don't think triple LTs are actually solving anything. I think they're fine, and we should totally allow them, but they're not going to solve anything. That's just there's not enough there to actually make a meaningful dent in anything.
Yeah, so. One of the primary arguments against when it was considered here at the MSBA is, so what? We get 5 of them. What's the point?
It's not a reason to do it, but what frustrates me is how much time and effort has gone into deciding whether or not to allow legal technicians, and it's not going to fix the problem, and it's not a threat to lawyers, and so of course we should do it, because there aren't any actual real good objections to it. So let's do it, but let's not fool ourselves that we're solving access to justice by doing it.
Right. Yeah, I think Landon should be here, our co-host. He wasn't able to make it this morning, but he sort of took an interesting path around the triple LT. He was against it early on, seeing them as competitive, and sort of came around to a view similar to yours. I think I don't want to speak for him, but if he's listening in, he can correct me in the chat.
There's definitely, there's no evidence that they have been competitive in. Timothy asks, why did Washington get rid of its triple LLT program? Because it wasn't doing any real good. I think it was more work to maintain the program than there was interest in it. Because the idea that law school loans are the primary reason that legal fees are high is totally wrong. Legal fees are high because rent is high, because it costs money to rent an office and to have malpractice, and it just takes money to run a business. And so the idea that you can go to cheaper law school and then your fees will be lower is wrong. You can't open a business for less than it costs to open a business. So I think there were just some flaws, and it became, they had graduated a few dozen maybe triple LTs in Washington, and there wasn't even a blip on the access to justice gap there. So.
Tell us about gender and AI assistance.
They're all named after women.
Yeah.
And especially when you join this to the fact that there were only 3 women founders among the 15 competitors, it feels problematic. And I pointed this out in the chat, and the marketing director from Dorothy points out, yeah, but ours is named for a famous Black computer scientist, Dorothy, whose last name I forgot. A company that is founded by two white men transforming a black innovator and inventor into an AI servant does not seem like a good look. So I don't think that actually in any way absolves my concerns around this. It's not necessarily like, so I linked to an article under the It's Certainly Not a Clear-Cut Issue from 2016, pointing out that there's more here than just like it's automatically bad. But there is more going on than just like don't automatically name, but I think don't automatically name your AI. Don't give them a woman's name and don't give them a woman's voice automatically is probably good advice for anyone starting a company. Think about it. Decide, because you're basically, AI assistants are assistants. They are low-level servants in your business, and giving them all women's names and voices seems very problematic to me. So, and deserving of some real consideration.
Yeah, I had similar concerns about when many of them are partners, whom I love, I have to say, the receptionist services, fantastic resources, which our members love, Smith AI,
Back Office Betties, Ruby Receptionist.
Back Office Betties. But if you look at those websites and their names, it's a heavily feminine, and why again are the assistants, why is that a gendered thing?
And nobody individually is probably coming to this with malicious intent. Like, I'm not saying that this is the kind of thing where people are intentionally doing this, but intentional sexism and racism is not the problem that we are mostly facing in this world. It's people with good intentions who are doing things that are problematic. And so I think it's at least worth pointing out that the next person to create an AI it'd be nice if they didn't just give it a woman's name.
Well, with Cortana, I think you've got a little bit more of a problem. I mean, there you've got a sexualized female in a video game for 12-year-old boys. So yeah, I mean that's maybe a little. Sorry, Mike. Michael, I interrupted you.
No, I was just going to say there was also a presentation by Darla Jackson on algorithmic AI that I thought was interesting because, to Sam's point, there's bias like everywhere, right? Littered behind things that we never think about, and so that's, I mean, such a relatively hot topic for trying to figure out how to parse that, or at least make it, like you said, Sam, think about it before
pivoting off of that, there's been an interesting, so both, I think Microsoft and Google and a few other companies have all tried the experiment of, well, let's use Twitter as our training data, because the bias often introduces itself in training data, right? So like if you train an AI to recognize faces using a publicly available database of faces, like say mugshots, well, your AI is going to get the idea that most people who commit crimes are Black when that actually isn't the case. Most people who are arrested and put in jail are Black, but they are not by the majority of people who commit crimes. And so your AI is going to develop if it sees a Black person, it's going to give them a bias towards assuming they've committed a crime. So, so training data is usually where the bias creeps in when we're talking about AI and machine learning and training. But anyway, so back to my point. So why not use Twitter, which is this huge publicly available data set, to train your AI? And nobody should be surprised when all of the AIs that have been created with that in mind turn out to be horribly racist, sexist misanthropes. So you have to be careful about your training data and what kinds of biases you're introducing. On the flip side of this, what we're seeing is in AI research, responsible AI companies are also starting to be able to tell you and build in, because this is really important, the AI should be able to explain to you how it made its decision. So to use a completely unproblematic example, let's say you're just trying to train an image recognition algorithm, and you're trying to figure out how to train it to recognize tractors in images. And so you feed it a bunch of images of tractors and cars and trucks and trailers and things like that. And it's likely to get the idea that if an image has more green in it, it's more likely to have a tractor, which is useful to know when you give it an image of a car sitting on a lawn and it tells you it's a tractor. Why did it make that decision? Because your car was sitting on a lawn. Oh, well, maybe we need to remove color from its, or reduce the impact of color on the way that it thinks through its image analysis. So your AI should be able to tell you how it's making your decisions, so that if it comes up with some bad ideas, you can tell it not to use those bad ideas.
See, I thought it would have been John Deere caused that.
Or that,
switch.
yeah. Yep. Yep. If it is a grass green car, then it probably is a John Deere. You're right. That's totally valid.
Fastcase used to legal research. That used to be a concern over the black box algorithm.
Mm-hmm.
How you're getting your results, which I totally understand. I think it's a little overplayed. I think if you're getting, and in fact, I think Fastcase took away their that advanced search. Used to be able to see how and adjust, in fact, to the algorithm for the relevancy
I think
ranking.
you can still do some of that, yeah.
So you could say, well, I want stuff that's been used by other Fastcase users. So if I do a DWI search, I can say, the only purpose I could think of actually using that is maybe you're searching another jurisdiction and you think you found the right document, and so just reshuffle the algorithm, zero out all the other factors, and just rank up the folks who have read it or downloaded the document, just to see if that is in fact the document that's relied on by other members in that particular jurisdiction. That's kind of cool.
There's also sort of people love to talk about I can't remember what the name for the problem is, but they love to raise the specter of, do we really, what about the problem of a robot car deciding who to save if it can save somebody in a split second in an accident? Well, anyone who is about to get in an accident is making that exact same decision. So the important question is not that's a problem, don't have self-driving cars. The question is how do we tell the self-driving cars who to save in a situation like that? Will Smith was really angry at robots in the movie I, Robot because he got saved in an auto accident instead of the kid. And the robot said, well, I knew there wasn't a chance there was a greater chance of saving you than the kid, so I saved you. Well, okay, maybe in the future we train our robots to default towards saving the kid, even if there's a lower chance of success or something. But the reality is people make those decisions too. The fact that we can train a robot to make smarter decisions should be a great thing. And we just have to set some boundaries around, what kinds of things we need to train people to how to make those decisions. So AIs get better at people only have one chance to make that decision usually, and AI will have many chances to make that decision. And so we can actually look forward to better decision making and fewer fatal accidents over time if that's a real thing. So
there's a great book by what's his that's all right, we can go off topic.
I will take any excuse I can to talk about robots.
There's a great book by Leo Katz, not the cats from which is on your list, but he writes a book about avoisions, about loopholes in the law. Talks about whole book about that deontological problem, I think is the term. Oh gosh, what is that called? The trolley. The trolley.
Yeah.
You're at the switch, and it's gonna either hit an elderly gentleman or a family of 10.
Yeah.
What's your so obviously, and then
the answer seems obvious to me that you would save the family of 10, but and I don't have any trouble
making that decision, right?
Nope.
Right. Lawyers still. I appreciate you writing this article. It's a great crib sheet. We can just easily run through the. I don't have to do any work for the.
Good.
Interesting. So you felt that a lawyer's still struggling with technology. Is that based on comments in chat, or?
It's primarily based on the audience, not the presenters. I mean, tech show the presenters are not the issue. I mean, it's just. Look, this is what I've done for 13 plus years, is try to persuade lawyers that it's okay to go paperless. Although in recent years, they're just look, I'm not going to have this conversation anymore. if you want to sit with if you're coming up with objections, it's not about persuading you. It's you just don't want to, and that's fine. Don't watch everybody else run past you. Yeah, but I think there's still this idea that the objection of I'm too busy practicing law is an interesting one to me, because what they're saying is I have an outdated idea of what it means to practice law. Because practicing law is finding more efficient and effective ways to serve your client. And so that means practicing law is a part of practicing law is being responsible about how you use technology and using it to, like, I think it's totally irresponsible to manually review documents at this point in any kind of scale. If you're doing a few of them, obviously, but like if somebody drops off banker's boxes, or more likely a CD-ROM or a USB drive, or gives you a bulk download of documents, and your idea of doing that is I'm going to spend the next 2 weeks billing by the hour while I manually review every document, I actually think you're probably committing malpractice, because you're not as good as an AI assisted document review plus you. The two of you working together are going to be more accurate, and it's also going to be way cheaper. And so I think it's irresponsible to not take advantage of technology. And one of the things that drives me batty is this idea that lawyers are adopting tech competence as a rule, which is BS. On Twitter yesterday, actually, a law librarian and I were talking about this, and she went and found the memorandum that I had lost track of. When the ABA Commission on Ethics 2020 promulgated the recommendation to adopt Comment 8 to Rule 1.1, they explicitly said, this is not a new obligation. Lawyers have always had the duty to be technologically competent. And if you aren't technologically competent, you're not competent to practice law. You are not professionally competent. Those are intertwined. And so lawyers are sometimes like, oh, it's just a comment. It's just an advisory. No, it's comment to explain that you've always had this obligation. And essentially the promulgating memo was like, my paraphrase of it is, we can't believe we have to say this, but of course, you cannot recklessly use technology to serve your clients, or recklessly ignore technology, which is essentially what you're doing if you're saying, I don't have to be technologically competent. Of course you do. But that's true. That's not very empathetic. But like, I get it. Lawyers are still, it's a lot to get your head around. And if you're busy billing by the hour and just working away at stuff, like, when do you make time to figure out what software to use, and when do you make time to figure out your paperless workflow and stuff? And it's clear from the chat, though, that the chat's being the way people ask questions, and just like we're doing now, that the number of but is that ethical, is like, I hate that question, because it's usually,
well, we love you, Tim.
Yeah, not harping on you, Tim, but like, when paperless comes up, people are like, is going paperless ethical? Is it ethical to use the cloud? Like, come on, it's been ethical for 15 years, like.
But we do drill that into with the ethics. Now we're wandering now into Michael's realm, I think, quite a bit here. Mike, earlier you mentioned that you had the way the Next 20, the academic track, is progressed wasn't exactly the way that it had been envisioned. Tell us a little bit about what you're hoping for. Does it resolve this issue for us?
Well, so Sam's point is interesting, because when I think of tech competency and the things I'm trying to think about, it's like the actual use of technology to make your practice more efficient and better. But there's also that question about, do you understand technology and what problems it has for your clients, which is a slightly different thing. So it's sort of like, I noticed on your list, you have the Tiger incubator at Emory. So that's interesting, because I think of that actually as technology transfer, right? It's actually lawyers advising startups how to do technology work. So that's the practice of law. That's not making your law more automated. So part of the whole thing we need to figure out how to articulate slightly better is that distinction between, I need to understand technology and I need to understand how to use technology in my practice. And so Next 20, or at least the academic track, was in part trying to figure out how to sort of make those two things different. It's like talking about algorithmic AI bias is great, but that's really academic.
Yeah,
Right?
no lawyer needs to apply that stuff. Yeah.
Right, unless they're either a professor who's writing about it, right, or a judge who's got a rule on about
Or maybe advising a company, yeah.
or advising a company, right?
Yeah.
Versus just how do I incorporate AI into my practice? I mean, what does I
Mhm.
need to understand to do that, right? So the next 20 things are really designed. And then the other thing that we were focused on was trying to find that way for people in law school to interact with the practitioners in a way that you're really drawing, hey, this is what I need to know. So show, it's like sort of Sam's thing. We get somebody who's 5 years out, they're going to go like, I wish I had known X when I was in law school. So that's our way of trying to figure out, how to reverse engineer that now, get it in so that they're at least now we're on top of that. And so I think of it as a way to try and mine, the minds of the people who are out there trying to do this stuff, and then bring it back so that, because we're always a little bit behind, even though we should be ahead. And that was the point. Next 20 is we need to be ahead of the game as opposed to behind.
Yeah. Well, and I think the lawyers coming out of law school have some advantages, but there is a myth of the digital native, I think. Yep. But I think that's partly what's reflected in what I referred to earlier, is I think there's a critical mass of lawyers doing things in a more modern way. And I think it's a reflection of, you come out of law school and start to practice now, why would you look around and think, yes, I'm going to copy what everybody else has done? That feels kind of weird to me. But I didn't see these statistics at this tech show. I'm sure they're there, but every year they report on like lawyers' use of technology. Mm-hmm. And one of the things that comes up is lawyers use social media in much, much smaller frequencies than the normal population, right? So like the last year, I think I remember that it was something like a third of lawyers logged into Facebook once a month or so, or something like that, whereas 80% of the population does. And the problem with that is you're going to need to use Facebook to understand your client's legal issues. Right. If somebody is harassing your client, there's a really good chance that's spilling over onto Facebook and text messaging and whatever. And you need to understand how those platforms work. And, I think not understanding how, text messaging or messaging on Facebook or commenting on Facebook works is similar to not understanding how the mail works well enough to apply the mailbox rule. You have to understand how to lay a foundation for Twitter evidence in court, as if you're going to take a deposition of somebody that involves Twitter evidence, or you do. So you have to understand these things at least well enough to lay a foundation, I think.
Did you see the presentation with the
Twitter? Well, and that was a next 20 presentation, right? Because that was Jenny Wondercheck.
Oh, it was, right.
Debbie Ginsburg, right? So law librarians were presenting there, and they used that.
I have also been using that video when I present about tech competence for years. That my takeaway is the only thing that I took away from that was that nobody in the courtroom understand the first thing about Twitter.
Right.
Sorry, folks who are listening in. I'll try to find that.
Sure.
Video.
It's from the George. Is it George?
Zimmerman
from his trial, and the defense attorney was trying to make the point that the witness was connected to George Zimmerman's brother on Twitter, which she was, but he didn't understand it well enough to even make that point, and she didn't understand it well enough to know whether or not she was. It was just a travesty. So. And it was quite funny, and more recent example is the cat lawyer, which if you haven't seen the cat lawyer, then I don't know what rock you've been hiding under. Although in
I'm
some ways
that was actually a cat.
Yeah, I'm not actually a cat. In some ways it's an example of tech incompetence, but in another way it was also I appreciated that everybody was pretty chill about it, involved, and we just kind of rolled with it, because it is just the kind of thing that is happening right now, and it's hilarious, but it's not the end of the world. If you have to present your argument as a cat, it's actually not the end of the world.
I have to say, one of the big silver linings for me is, this keynote was casual, could hear the baby in the background. I'm like, great,
Yep.
let's live in the real world. No
Yeah.
hype man up on the stage. Are you ready? It's like, which has never been a real big ABA thing, I guess, at all anyway. But
that's a Clio thing.
That's a Clio thing. It is. Well, it's a lot of conference things. I really, it was straight to the substantive content. It was a great presentation, and it was real. I really appreciated it. Somebody, Kirk says, people who are not lawyers may do some quick research, then seize on the first legal solution they find, for sure. The future software should ask more questions than just drill down in categories. It should lead the person through multiple ways to solve the problem. Sounds like an automation. Example, I was asked by a friend to create a legal document for lending to a relative. There was a lot more going on than the need for a promissory note, lending to relatives. Yeah, there were a lot of go ahead, Mike.
And Mike, sorry, one thing I noticed that the Bob Ambrosi thing you put in was for 2020. So I just
was it
put
the
in the
last
2021.
year? Yeah, appreciate that.
Yeah.
Hey, Mark Sarnick.
It's the librarian in me. I'm sorry, I couldn't help myself.
Have a hard time walking and chewing gum at the same time sometimes. We're coming up at the top of the hour, so I want folks to get in their last comments and questions. I'm going to dig out. I still haven't found the Zimmerman. It was the Zimmerman trial, yeah.
Yeah, it was. It's
Zimmerman.
And my last point on here was really something we've already discussed, which is that, at the same time that some lawyers are struggling with tech competence, some lawyers are very tech savvy and doing things in a modern way. And we've kind of talked about that. My sense is that there is finally sort of that dividing of the profession where there's very traditional, not willing to change lawyers, and lawyers who are, doing things in a new way. What I don't have the answer to yet is, are the lawyers who are doing what I would call modern practice, are they actually making more money? Are they successful with those? Do they have a competitive advantage?
What do you think about?
We know yet.
Cleo's argument would be yes, they have a interest in that. But their recent legal trends report said that surviving the pandemic were the folks who, although it was a modest gain, were folks who adopted technology, automated features, payment processing systems, et cetera.
I mean, it seems obvious to me that building a service model around your clients' needs and concerns, and then delivering on that using efficient practices that are more efficient, more effective practices should obviously be more profitable. But obvious doesn't always work. And so, I'm willing to say that I don't have a conclusion yet. But it does seem pretty clear, like when I put myself in a consumer's shoes, it's obvious to me who I would prefer to work with. But who knows? I'm not sure yet. I'm not sure that we can say yet whether or not new models have been successful, or if we have there's beginning to be a sort of a clear what the new model is, I think, but whether or not it works is potentially not completely proven. While I was at Lawyers, we definitely saw a lot of success from people who were doing it that way, but that's anecdata. That's not real data. So I don't want to claim anything. Timothy found it.
Yeah, thanks. I dropped in a YouTube video. Hopefully it's not porn. I think it's the Twitter.
YouTube doesn't allow that.
So yeah, thanks Tim for doing that. Read Tim's, not mine. Yes. Question from Kirk: is AI going to actually help people realize that their real problem is not the only one they think it is? Some medical sites actually do help with this.
Yes, but I think that's not what most of the AI coming into legal in the world of law practice is designed to do. Most of the AI coming into the world of law practice is designed to be the lawyer's assistant, to help the lawyer figure things out. So, for example, like one of the reasons documents are coming in is because reading and understanding documents is something that AI is actually really good at and people are not as good at. because, think of just identifying cancellation provisions in contracts, for example. You can train an AI to understand in the way that a lawyer would, and in a way that an AI would, all of the different variations of what cancellation terms would look like. And the more data you feed it, the better it gets at that. And there's no reason to go sick an army of contract lawyers on that when you can have a few people quarterbacking the AI and making sure that it's complete. You can get close to 100% accuracy when you have an AI assistant, where you might only be at 80% or less accuracy without an AI assistant, in part because you can't review all the contracts, but with an AI you can. And you can do it quicker and more efficiently and for potentially less money. Or, as I think Kira points out, if you can, like, imagine you're trying to merge two companies. Traditionally, you would review about 10 or 20% of the contracts, because you can't review 100% of a million contracts. And so you would take a sample of the important contracts, and you would hope, and maybe you'd spot check in a non-scientific way, you would spot check the rest of the other 80% contracts. So you might do, a few dozen or maybe 100 randomly, but not actually randomly selected samples, like you'd ask general counsel to give you a few others to spot check. But the problem is there may be big problems in those contracts. There may be cancellation provisions or something that cost you a lot of money. And normally companies just say, well, it's acceptable risk. But with an AI, you can check 100% of the documents. And what you can do is you do sort of a heavy AI plus lawyer review of your 20%. And then you offer to your client, we'll actually hit the other 80%. So we'll get you to 100% review. We'll just let the AI surface problems for us on the other 80%. We'll only review them if the AI tells us there's an issue there. And so you actually might be able to have a bigger legal fee because you're offering 100% coverage, which companies want, there's no conceivable way you could offer 100% coverage for something that they'd be willing to pay. That's like a big corporate M&A example, but the AI is usually, I think in many of the tools we're looking at, the AI is an assistant to you, the lawyer, to make you better at your job, to give you more options for what you can offer to clients, and potentially sometimes to do it for less, sometimes to offer more for more. And so there's definitely consumer-facing AI, and like the do not pay bots are an example of this. I'm not excited about those as like transforming the industry. Yeah. I think what's more exciting is, how do you get cooler AI assistants for lawyers, because that's how lawyers get better. So
to Brian's point, we warmed up the crowd at the end of the hour.
Yeah, here, we did.
Addressing Laverne's here. Laverne, Laverne was one of our advocates of the uniform citation. He worked with us in that project. But to Brian's point, on the economics of this, I mean, as you're describing some of these tools are available now. And Brian's point, I think, has to do with what's available in the short term, midterm, long term. Price isn't the only consideration.
I mean, his point, I think we sort of addressed it, but like one option is to take the increased efficiency and just charge less. But another option is to take the increased efficiency and offer more and charge more for it. And it's it's called the Jevons paradox or something, is that as things get more efficient, people buy more of it, not less of it. And so the idea that, why do I want to be more efficient if I'm billing by the hour, is a very, very narrow, nearsighted way of responding to this. If refrigerator companies had said, why do I want to make refrigerators more efficient and cheaper, we wouldn't all have an extra fridge in the garage. Like, there's more refrigeration happening in the modern world than there ever was before, because fridges got cheaper and electricity got cheaper and easier, to use one example. And there's already some evidence that making law more efficient means you get to sell more legal services. And so you don't have to charge less because you're able to do more in less time. Only some clients want that, and you can offer that to clients. Other clients will actually take the premium service where you do more for more.
which doesn't bode well necessarily for the access to justice side of things, I would think. I mean, if you're increasing your effective hourly rate by automating a process, you're still charging the hourly rate that you used to charge, even though you're more efficient, and not necessarily reducing your cost until that service is available, broadly to everyone.
Maybe. Yeah, maybe. I mean, I think doing less work for less money is where I think a lot of there are some people who are simply priced out of hiring a lawyer. And for those people, limited scope representation / unbundled services, flat fees, all of those are things that can increase your effective hourly rate and lower the cost to the client of what they're buying at the same time. And so there's plenty of opportunity for win-wins here by getting more efficient, that will have an impact in access to justice. I am uncertain how much we can close the gap just by lowering costs. Because there's all this data that more than half the country says they can't come up with $400 in an emergency. I can't imagine that number's gotten smaller during the pandemic. So unless you can get your fee below $400, some meaningfully below $400, I'm not sure we're actually having a conversation about closing the access to justice gap. So,
and I appreciate your comments earlier about the latent legal market, which may or may not exist.
I'm not sure. Nobody should take that in I wouldn't make business decisions around that, but I am not sure how much of the latent legal market is real. So, and I used to be a huge the fact that we talk about it in that way, I may be a primary contributor to the fact that we all talk about the latent legal market. So,
we can blame it on you. Yeah. First, I heard it was
definitely deserves some of it.
I gotta cut us off, but let's just finish with Laverne here. Is AI going to help people realize that the real problem is not the only? I'm sorry. Did we address
his ontology or knowledge graph? I mean, I know you guys have talked about Sally before, which is, I think, probably the preeminent effort to create that sort of taxonomy that you need in order to get computers understanding things in the legal world. So it hasn't happened yet. Right now, you need to plug your machine learning project in and let your AI try and assign that taxonomy to things. Hopefully Sally takes off and that becomes the way that computers are starting to be able to have conversations about legal topics with each other.
I think that discussion of ontology versus taxonomy is the subject of Damien's video.
That's a Damien question.
But if folks have, in fact, I might even have it up here. I do. How do you like that? It's just at sally.org, right on the front page, I think. Damien's discussion on using Sally. We weren't able to get to that. We could spend the day reprising what we thought about the tech show, but I should let you guys have your day back. The CLE code for folks who may be calling in is 348-329. That's 348-329. Thanks everyone for joining us. We're on again April 1st to talk about the new access to court records available from Minnesota. Very cool feature. Have you guys had a chance to take a look at that tool yet? It might
I just learned about it last night, actually.
Yeah, email came out yesterday and Landon said, you can talk about it now. And I said, well, I'm excited to do that, actually.
Yeah.
But we'll have a full discussion on that on April 1st. Thanks again to our sponsors, Taft and Sherry's Access to Justice Project. Remember to sign up for your North Star certification at minbar.org. Have a great day, everyone. Take care.
Thank
you.